This is part 54, and we start discussing chapter 10 of the Indian Penal Code, which deals with contempts of lawful authority of public servants. As we go through each section, which is must, during course of time you will understand that this has got reference to procedural law, and hence, as and when it is possible, I will refer to it. But then once you understand procedural law, you will understand importance of this chapter. For example, now, as we are supposed to start right from section 172 up to section 190. Section 172 deals with absconding to avoid service of summons or other proceedings. And what it says, whoever absconds in order to avoid being served with a summons, notice or order, or other order proceeding from any public servant, legally competent as such public servant to issue such summons, notice or order, shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. Or if the summons or notice or order is to attend in person or by agent, or to produce a document or electronic record in a court of justice with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. Now during course of time you will understand importance of the summons, especially if you refer to right from section 61 up to section 90 of the Criminal Procedure Code. As far as criminal law is concerned, there is also provision of summons as far as the civil law is concerned. Then summons is the direction which is given to an individual to remain present. And hence here, now when a person is summoned, for the purpose of what? So with a notice, with a summons, notice or order, and then if he absconds to avoid service of summons, then he is made punishable as far as section 172 is concerned. So summons is a direction, or there can be written, if a police officer wants somebody to come to the police station for the purpose of recording his statement, he can by all means call that person to the police station as far as section 160 of the Criminal Procedure Code is concerned. But if there is a person absconds to avoid service, then in that case he is punishable as far as section 172 is concerned. Section 173 deals with preventing service of summons or other proceeding, or preventing publication thereof. And it says, whoever in any manner intentionally prevents, so he intentionally prevents the serving on himself or on any other person of any summons, notice or order proceeding from any public servant, legally competent as such public servant to issue such summons, notice or order, or intentionally prevents the lawful affixing to any place of any such summons or notice or order, or intentionally removes any such summons, notice or order from any place to which it is lawfully affixed, or intentionally prevents the lawful making of any proclamation under the authority of any public servant, legally competent as such public servant to direct such proclamation to be made, shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. Or if the summons, notice or order or proclamation is to attend in person or by agent, or to produce a document or other electronic record in a court of justice with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees. Now when you shall be dealing with service of summons, then you will come to know there can be what is known as personal service of summons. A summons can be served upon any adult male member of the family, and is servant is not a member of family with the meaning of this section as far as section 64 is concerned, and if it cannot be served in any one of these manners, namely personal or extension, there is a provision of affixing a copy of a summons to some conspicuous part of the house where the person ordinarily resides, what is known as substituted service of summons. In case of proclamation also, when you shall be dealing with the chapter, namely right from section 61 up to section 90 of the Criminal Procedure Code, you will come to know that there is a provision if a person is served with a summons and if it doesn't remain present. If a warrant is issued but warrant cannot be executed, a court has got power to publish proclamation, and hence that is what is known as proclamation. You can understand by reading section 81. In order to know summons, you have to start right from section 61 up to section 69 of the Criminal Procedure Code. To know warrant, you have to start right from section 70 up to 80, up to section 80, and then when you read the next section, you come to know what they mean by proclamation as far as so this chapter right from section 61 deals with summons, warrant and proclamation. Proclamation, and the last part deals with what do you mean by attachment of the property. These are the ways where a person can be compelled to remain present in a court of law. Right from section 91 up to 105 of the Criminal Procedure Code is the chapter which deals with compelling production of a document or thing, and hence when a document is required and if the person doesn't, he is liable as far as the section, namely section 173 is concerned. Section 174, non-attendance in obedience to an order from public servant, and it says, whoever being legally bound to attend in person or by an agent at a certain place and time in obedience to a summons, notice or order or proclamation proceeding from any public servant legally competent as such public servant to issue the same, intentionally omits to attend at that place or time, or departs from the place where he is bound to attend before the time at which it is lawful for him to depart, shall be punished with simple imprisonment for a term which may extend to one month, or with fine which may extend to 500 rupees, or with both. Or if the summons, notice, order or proclamation is to attend in person or by agent in a court of justice, with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. With this now, section 174 capital A deals with non-appearance in response to a proclamation under section 82 of the Act 2 of 1974, namely the Criminal Procedure Code. And it says, whoever fails to appear at a specified place and specified time as required by proclamation published under subclause 1 of section 82. So there I mean section 82 of the Criminal Procedure Code deals with proclamation, the way in which you can compel appearance of a person in court of law, and 61 to 69 deal with summons, 70 to 81 deal with warrant, 82 deals with proclamation, and 83 onward deals with attachment of the property. And what it says, whoever fails to appear at a specified place and a specified time as required by proclamation published under subsection 1 of section 82 of the Code of Criminal Procedure shall be punished with imprisonment for a term which may extend to 3 years, or with fine, or with both, and where a declaration has been made under subsection 4 of that section pronouncing him as a proclaimed offender, he shall be punished with imprisonment for a term which may extend to 7 years and shall also be liable to fine. Section 175. Omission to produce document to public servant by person legally bound to produce it. Whoever, being legally bound to produce or deliver up any document or electronic record to any public servant as such, intentionally omits or to produce or to deliver up the same, shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. Or if the document or electronic record is to be produced or delivered up to a court of justice, with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. With this now section 176. omission to give notice or information to public servant by person legally bound to give it. And says, whoever being legally bound to give any notice or furnish information on any subject to any public servant as such intentionally omits to give such notice or to furnish such information in the manner and at the time required by law shall be punished with simple imprisonment for a term which may extend to 1 month or with fine which may extend to 500 rupees or with both. Or if the notice or information required to be given respects the commission of an offence or is required for the purpose of preventing the commission of an offence or in order to the apprehension of an offender with simple imprisonment for a term which may extend to 6 months or with fine which may extend to 1000 rupees or with both. Or if the notice or information required to be given is required by an order passed under subsection 1 of section 565 of the Code of Criminal with imprisonment of either description for term which may extend to 6 months or with fine which may extend to 1000 rupees or with both. Now, if you read Criminal Procedure Code, you have just 484. This section is from Criminal Procedure Code of 1898, which has been repealed because of the Criminal Procedure Code of 1973. So you have to read the corresponding section as far as this order which is laid down as far as this section is concerned, namely. But you won't read this section 565 as far as the Criminal Procedure Code which is applicable nowadays within the territory of India. So now this is 176 deals with what? When you are aware regarding commission of an offence, whether you are bound by law to give information, and then for that, this is the time for me to draw your attention as a student of law to section 39 of the Criminal Procedure Code. And when you read section 39 of the Criminal Procedure Code, you come across 12 categories of the offences. If somebody is aware regarding commission of an offence or intention to commit any one of the serious offences which are enumerated as far as section 39 of the Criminal Procedure Code is concerned, he is bound by law to set law into motion as far as section 176 is concerned. If you read section 40, that section deals with what? That section deals with 6 categories that are enumerated, and those are with respect to whom? One who is residing in a village or who is a village officer must give information to the nearest police station or to the magistrate, and if he doesn't, his liability is as far as section 176 is concerned. Whereas if you have information and you have given false information, liabilities as per next section 177, which says furnishing false information, which says whoever legally bound to furnish information on any subject to any public servant as such furnishes as true information on the subject which he knows or has a reason to believe to be false shall be punished with simple imprisonment for a term which may extend to 6 months or with fine which may extend to 1000 rupees or with both. Or if the information which he is legally bound to give respects the commission of an offence or is required for the purpose of preventing the commission of an offence or in order to the apprehension of an offender with imprisonment of either description for term which may extend to 2 years or with fine or with both. With this now, as you read, the explanation to the section says, in section 176 and in section 177, the word offence includes any act committed at any place out of India, which is committed in India would be punishable under any one of the following sections. And the sections are enumerated, and the word offender includes any person who is alleged to have been guilty of any such act. So that is the explanation which is given. With this, section 178, refusing oath or affirmation when duly required by public servant to make it. It says whoever refuses to bind himself by an oath or affirmation to state the truth when required to so to do, bind himself by public servant legally competent to require that he shall so bind himself shall be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Section 179. Refusing to answer public servant authorized to question. And it says, whoever being legally bound to state the truth on any subject to any public servant refuses to answer any question demanded of him touching that subject by such public servant in the exercise of the legal powers of such public servant shall be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Section 180, refusing to sign a statement. And it says, whoever refuses to sign any statement made by him when required to sign that statement by a public servant legally competent to require that he shall sign that statement shall be punished with simple imprisonment for a term which may extend to 3 months, or with fine which may extend to 500 rupees, or with both. When, as far as the setting of cognizable offence is concerned, when you will deal with section 154 of the Criminal Procedure Code, you will come to know that person who gives information which reveals commission of a cognizable offence, if it is given orally, that is reduced into writing, and when it is reduced into writing, the person who gives that information, it is read over and he is asked to sign the same. So this is a statement refusing to, if he says that, well, I am not going to sign the same, a statement made to the police as far as during the course of investigation, if you read section 161 to be read with 162 of the Criminal Procedure Code, is not required to be signed. But this is a statement that is popularly known as FIR. That is, that becomes FIR, or that is FIR. So that is required when you sign it. That is what is known as first information, and as that is a document that is popularly known as first information report. But if the person refuses to sign, his liability is also as far as section 180 is concerned. 181. False statement on oath or affirmation to public servant or person authorized to administer an oath or affirmation. And it says, whoever being legally bound an oath or affirmation to state the truth on any subject to any public servant or other person authorized by law to administer such oath or affirmation makes to such public servant or other person as aforesaid touching that subject any statement which is false, or which he either knows or believes to be false, or does not believe it to be true, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. This is the section. Now, in order, we have come across here, what do you mean by oath? And in order to know oath, you have to go back to general explanations and read section 51, which defines oath. It says, the word oath includes a solemn affirmation substituted by law for an oath, and any declaration required or authorized by any law to be made before a public servant, or to be used for the purpose of proof, whether in a court or justice or not, court of justice or not. So that is as far as section 51 of the which defines oath is concerned. With this now we come to section 182, which says false information with intent to cause public servant to use his lawful power to the injury of another person. And it says, whoever gives to any public servant any information which he knows or believes to be false, intending thereby to cause, or knowing it to be likely that he will thereby cause such public servant to do or omit to do anything which such public servant ought not to do or omit, if the true state of facts respecting which such information is given were known by him, or to use the lawful power of such public servant to the injury or annoyance of any person, shall be punished with imprisonment of either description for term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Section 183. Resistance to the taking of property by lawful authority of a public servant says, whoever offers any resistance to the taking of any property by the lawful authority of a public servant knowing or having reason to believe that he is such public servant, shall be punished with imprisonment of either description for term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. Now, when the order is given or the public servant came for the purpose of attachment of the property, and if there is a resistance to the taking of such property, then he is liable as far as section 183 is concerned. 184, obstructing sale of property offered for sale by authority of a public servant. Whoever intentionally obstructs any sale of property offered for sale by the lawful authority of any public servant as such shall be punished with imprisonment of either description for term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. Now, when there is resistance to taking of property, when the property is attached and when it is required to be sold in an auction sale, if somebody obstructs the sale of property offered for sale by authority of a public servant, is punishable as far as section 184 is concerned. 185, illegal purchase or bid of property offered for sale by authority of a public servant. Whoever, at any sale of property held by the lawful authority of a public servant as such, purchases or bids for any property on account of any person, whether himself or any other, whom he knows to be under a legal incapacity to purchase that property at that sale, or bids for such property, not intending to perform the obligations under which he lays himself by such bidding, shall be punished with imprisonment of either description for term which may extend to 1 month, or with fine which may extend to 200 rupees, or with both. Section 186. Obstructing public servant in discharging of public functions. Whoever voluntarily obstructs any public servant in the discharge of his public functions shall be punished with imprisonment of either description for term which may extend to 3 months, or with fine which may extend to 500 rupees, or with both. So, obstructing public servant, as far as his public functions are concerned, discharging his public functions are concerned, is made punishable as far as section 186 is concerned. 187. Omission to assist public servant when bound by law to give assistance. And it says, whoever being bound by law to render or furnish assistance to a public servant in the execution of his public duty intentionally omits to give such assistance shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 200 rupees, or with both. And if such assistance be demanded by him by public servant legally competent to make such demand for the purposes of executing any process lawfully issued by the court of justice, or of preventing the commission of an offence, or suppressing a riot or affray, or apprehending a person charged with or guilty of an offence, or of having escaped from lawful custody, shall be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 500 rupees, or with both. Now, omission to assist. For that, this is the time for me to draw your attention to section 37 of the Criminal Procedure Code, where your duty is cast when there is reasonable demand on the part of the police officer or the magistrate for your aid and assistance, and the 3 categories are enumerated, and if you do not, then your liability is as far as section 187 of the Indian Penal Code is concerned. 188. Disobedience to order duly promulgated by public servant. And it says, whoever, knowing that by an order promulgated by public servant lawfully empowered to promulgate such order, he is directed to abstain from a certain act, or to take certain order with certain property in his possession or under his management, disobeys such direction, shall, if such disobedience causes or tends to cause obstruction, annoyance or injury, or risk or obstruction or annoyance or injury to any person lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 200 rupees, or with both. And if such obedience causes or tends to cause danger to human life, health or safety, or causes or tends to cause a riot or a fray shall be punished with imprisonment of either discretion for term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. And the explanation says, it is not necessary that the offender should intend to produce harm or contemplate his disobedience as likely to produce harm. It is sufficient that he knows of the order which he disobeys and that his disobedience produces or is likely to produce harm. Section 189, threat of injury to public servant. It says, whoever holds out any threat of injury to any public servant or to any person in whom he believes that public servant to be interested for the purpose of inducing that public servant to do any act or to forbear or delay to do any act connected with the exercise of the public functions of such public servant shall be punished with imprisonment of either discretion for term which may extend to 2 years, or with fine, or with both. With this now, the last section, section 190, deals with threat of injury to induce person to refrain from applying for protection to public servant. And it says, whoever holds out any threat of injury to any person for the purpose of inducing that person to refrain or desist from making a legal application for the protection against any injury to any public servant legally empowered as such to give such protection or to cause such protection to be given shall be punished with imprisonment of either discretion for term which may extend to 1 year, or with fine, or with both. With this now, we intend to start with chapter 11, where we shall be dealing with false evidence and offences against public justice, right from section 191 onwards. Now this is, a lengthy chapter, but let me tell you, this chapter also needs some understanding of the procedural law. During course of time, I shall try to simplify, but in order to have mastery as far as this is concerned, you must and that is simultaneously, if you learn the procedural law, no problem, but then we shall be dealing with false evidence and offences against public justice right from section 191 up to section 229A of the Indian Penal Code as far as next part is concerned.